Huh.
Okay, well, why don't we go ahead and get started? I'm so happy that you have joined us today. It's always, our doors are closed and we miss our community, but even though it's virtual, it's still really good to see you and to be together. So thanks for taking the time at the end of your day, hopefully before dinner and a nice night that you have ahead of you. I am Libby Eppinga. I'm the Director of Donor Support and Capital Campaign here at Cancer Support Community. So that basically means I help work on the future of the organization with estate planning, planned giving, wanting to provide our members and donors with education and information. So what we decided to do was create a legacy advisory council group that could do that for us with their expertise. So Ivette is one of those members. I'm going to start with a bio on Ivette so you can know how amazing she is. She might be embarrassed. She doesn't know that I'm doing this.
Skip that.
But Ivette is based out of San Ramon as the owner of Santaella Legal Group, a professional corporation, practicing estate planning and elder law. She graduated with honors from Fordham University in New York City, where she went on to work for the city of New York in various management positions before attending law school in Washington, D.C. at the American University Washington College of Law. Ivette obtained her MBA from the University of California at Irvine. Something to note is she's also fluent in Spanish, where she would really like to support CSC in that way as well. She has considerable experience, obviously, in estate planning, elder law, special needs, trust administration, conservatorship, sorry, that was a bleh, and nursing home abuse. She is knowledgeable in long-term care and Medi-Cal planning. She's drafted numerous wills, trusts, durable power of attorney, and other relevant estate planning documents. She's made various presentations like the one she is about to give today. She's an active member and volunteer with the Contra County Bar Association, Wealth Council, numerous other things, as well as now Cancer Support Community. So there is much more to say and know about Ivette. I will be posting her website in the chat box so you can learn more about her if you would like. Just some Zoom etiquette before we begin. This is being recorded. So if for any reason you're uncomfortable with being recorded, just let me know afterwards or feel free to turn off your camera if you don't want to be seen. Basically what we do with it is we put it on our website for others to view it later. Ivette also is happy if you interrupt her with any questions that you have at any time. So whether you unmute yourself or use the chat box, she'll be happy to answer throughout her presentation. So Ivette will start with her presentation and then have hopeful discussion afterwards. Okay. So I will make you the host. Okay. Hi, Mary. Welcome.
You're the host. Okay, thank you. Thank you, Libby, so much for this opportunity to make this presentation and meet everybody. I want this to be an experience where I can give you information that's helpful to you. So please feel free to interrupt me or ask me any questions. We only have like an hour, and Libby wanted me to talk about Medi-Cal planning, conservatorship, and special needs. And each of those topics would take its own course for like 2-3 hours. So I'm going to do a very high level view and give you some information to get you started. And if you have any questions, you can ask me now or ask me. You can call me. I guess Libby will give you my information. Just feel free to call me if you need any information or anything. I used to be a corporate lawyer, and I got into this area of the law because of what I went through personally with my mother. I didn't have a clue about anything about Medi-Cal planning or estate planning. And when she got sick with Alzheimer's, I realized that there was a lot I needed to learn. One thing was that she was a judge in New York City, and she didn't have her own estate plan. And the reason was because she didn't trust anybody. She didn't want to give up control. When she realized she needed to do it, it was too late because her mental capacity was gone. But unfortunately, because of the illness she had, I tried to take care of her 24/7, impossible. So I had to put her in a skilled nursing facility and used all her money to pay for it. I didn't realize that Medi-Cal, especially in California, has a long-term care insurance that will pay for the care. And you don't have to be impoverished to qualify. There's a lot of things that you can do in California that you can't do anywhere. It not only helps you qualify, but it also helps you protect your assets. So let me now try to share my screen so I can show you my, Libby, where do I get the share my screen thing again? It's, oh, you're on mute.
Sorry about that. The bottom of your screen.
There it is. It just popped
Okay.
up. Darn thing. Okay. Here it is. Share. Please bear with me. I'm not very good with Zoom. Here we go. I think. Do you see it?
We see it.
Yay. And hopefully I can see it.
Yes.
Is it still coming?
We see it, just not in presentation mode yet.
Okay. So I'm going to start off with a disclaimer, which I have to do. State Bar of California requires me to make it clear that this is just presentation is just for informational purposes only. I'm not representing you as an attorney. I'm just providing information. If you need an attorney to help you with any of these things, please contact the Contra Costa Bar Association or the Alameda County or whatever county you live in. They have a bar association that'd be happy to help you. You are screen sharing. Okay, can you see it, Libby?
I can see it. If you could make it in presentation mode, that would be
Okay.
bigger.
Come on, you darn thing. Here it is. Okay.
There we go. Perfect.
Okay, so I'm going to first talk about Medi-Cal. So what is Medi-Cal? It's there's two kinds of Medi-Cal. There's one for long-term care and there's one for health insurance. I'm going to focus on the long-term care Medi-Cal, and that one pays for your expenses at a skilled nursing facility. Does not pay for assisted living. It would pay for at-home care, but you need to apply in advance and it's a long waiting list. It's very hard to qualify. So Medi-Cal is used to, it pays all your expenses in a nursing home, whatever you need. I'll show you the list of what it covers. Now, Medicare, they usually get confused. I guess it's because, you know, they're so similar. They sound so similar. Medicare is a federal insurance program paid from our Social Security deductions. It's an entitlement. We're entitled to it because we paid into it. So people over 65 or people under 65 with disabilities qualify. It pays for chronic care. It's like a health insurance for the elderly or the disabled. It's not for long-term care. That's what Medi-Cal does. So Medicare will cover the first 100 days if you're in the hospital or you're getting a rehab, full cost 100%. Then afterwards, you know, you have a copay and so on. Long-term care insurance, I hope some of you have it, because then with long-term care insurance, it's your own insurance and you have more options. You can use it in a skilled nursing, you can use it assisted living, you can have at-home care, you can use it for anything. And it gives you a daily allowance. Depending on the plan you have, how long you've had it, what are the perks, that would determine how you would use that long-term care insurance. Then if you don't have any of these, then you would be self-funding if you needed to go into a skilled nursing facility. And they average anywhere from 8 to 10, depending on the facility. And if you want to check out the qualifications or the ratings of the facility, you can go to medicare.gov and they have a link to the nursing homes, and the feds have hired a contractor to go every year and assess the nursing homes for, you know, cleanliness, how they treat patients, the staffing and things like that. So you can see, you know, who's rated well, who hasn't had a lot of complaints and which places have. Though I would highly encourage you to go visit it in person. It's not the same as seeing it on a website or on a TV. You have to go there and feel it and smell it and just make sure that you feel comfortable with it and you feel comfortable with the people there, because you're going to have your loved one living there and you want to make sure that they're well taken care of. If you have any complaints about the long-term care facility or the skilled nursing facility, the Ombudsman, a good place will have a big sign probably in the front that says, if you have any issues with us, contact the Ombudsman. And I'm on the board of directors of the Ombudsman, and they have teeth. They can really make a change. So if there's an issue, they can resolve it for you without you having to go to court or hire a lawyer or go through a bunch of changes. So keep in mind that if there's something you don't like that they're doing, they shouldn't be doing. Like, for example, if they want you to leave the facility, they have to give you 30 days notice and they have to give you a care plan. They just can't throw you out in the street. Signing, you don't have to sign everything. Just be careful what you sign. So the ombudsman, if you feel like you're not that comfortable with the facility, they'll come in and they'll help you. Any questions on this slide? Okay, so here we go with the laundry list of what Medi-Cal covers.
Yeah, I have a question on
Yes, sir.
your first slide.
Sure.
Are there any place or types of coverage, say like if you do not have social security, does that mean some of these things are not available to you?
Social Security will pay for whatever needs you have, but it's not enough. I don't know, Social Security depends on what you earned and how much you put into the system. I don't know how much you have, but
well, I have none. We have none
oh,
of these.
okay. So then if you had to go into a skilled nursing, then you could probably get help with Medi-Cal for long-term care. And
okay.
Yeah, it's needs-based. Medi-Cal is not an entitlement, it's needs-based. And I'll go into more detail on that. So Social Security, if you have it and you qualify for Medi-Cal, they'll use that money as part of your deduction. So you're going to have to contribute that money to help pay for your care. So they automatically take whatever money you get out of that, and then they cover the rest. Okay.
Okay.
All right. So so they cover the room, board, private nursing, hospitalization. It's not limited like Medicare. All your prescription drugs, some dental care, orthopedic devices, eyeglasses, health insurance premiums, physical and occupational therapy, mental and behavioral health treatments, outpatient, preventative and wellness services, hospice, and all medically necessary healthcare items. It doesn't cover private nurse, TV, or furniture, or anything like that. Any questions on this slide? Okay. So in order to qualify, you cannot have assets more than $2,000 in your name. There's exempt and non-exempt property. So for example, your house. California is the only state where you can exempt the full value of your house. You can have a $10 million house and still qualify for Medi-Cal. That's just the way California has set it up. You can have a car, you can have household good, personal effects, what have you. There's things you have to know how to, when you fill out the application, you have to know what to put in there so that they know that it's an exempt asset and they don't count it against you. Non-exempt is obviously something that they will count against you. Let me see, if you have over $2,000 in the bank or in a stock fund or what have you, if you inherit money, you have to tell Medi-Cal about it. You cannot, disclaim it and give it to somebody else. So this is a basic what you need to qualify. There's other things too, but this is basically what you need to know. So any questions on this slide?
So if you have questions on this, you need to contact what type of a lawyer?
A lawyer that specializes in Medi-Cal planning.
Okay.
There's few of them that do it. There's a lot of good ones in what county do you live in?
Alameda.
Alameda. I think there's some good lawyers there. And if you need, I can recommend somebody. Be happy to recommend someone. And they have the experience in how to help you qualify. I mean, if you have assets over $2,000, there's no reason for you to give it all away. And if you give it away, you're going to get penalized anyway. There's things that you can do that are perfectly legal and perfectly fair so that you can be eligible. Once you're eligible, then you have to deal with recovery because they will come knocking on your door to recover whatever they gave you after the surviving spouse passes. So there's a planning that you have to do. There's a lot of things, but it is doable if you need it. Obviously, for somebody who doesn't have that many resources, it's not that difficult to qualify. But people who have resources, there's things you can do like husband and wife. You can transfer everything over to your well spouse and you're not going to be penalized. It's just unbelievable what you can do. Or you can do what's called staggered gifting to your children. You can gift each day to each child 8,088, some odd number a day. And instead of being penalized for months, you're penalized for days. So you really need to talk to an attorney who does this, who does this as a profession, and they know all the rules. And you got to keep up to date because they change the rules all the time. Like I belong to a service that tells me when things change because I don't have time to look it up. But you have to be up to date because the laws change. Any questions on this slide?
Can I ask you one more question? My
Sure.
brother is over the age of 65 and he would qualify for this, but does it cover like drug rehab, alcohol rehab?
I wish.
Okay.
If it's a skilled nursing facility, I don't know if skilled nursing primarily, maybe it does. I don't know. For drug rehab, probably not.
Yeah, it's more
Because
alcohol.
yeah. I know that if you have Medi-Cal health insurance, they cover a lot of the health costs and programs versus having private insurance for that, for mental health and drug or alcohol abuse, because they have county programs. And surprisingly, you don't, if you have Medi-Cal versus private, you get more benefits. I guess because they figure people, with simple needs don't have the wherewithal to pay for insurance premiums. I don't know what the logic is, but I know that that's your best bet for that person. Okay.
Thank you.
Yvette,
Yes.
Yvette, before you move on, there was one question in the chat box from
Oh,
Tom.
yeah. Where?
How do you find it? It's hard when you're presenting.
Okay.
How do you find an ombudsman?
Okay. So just go to the website and just look at your county. So it's Contra Costa Alameda Ombudsman, and you'll get the information, the contact information there. So they will, if you have an issue with the nursing home, then they will send someone out to investigate, and then they'll talk to you and they'll talk to the nursing home administrator and try to find a solution. But they will find a solution. But I go on the website. If which county are you in, Toffee?
Costa.
Contra Costa. Okay, so just go look Contra Costa Ombudsman and you'll see it has all the information you need. All right, so how do you become eligible? Well, you have to be ill, obviously, in order to get to the nursing home. You have to be at least 65 years of age or legally blind or disabled by Social Security standards. Good luck trying to figure that out. It's very complicated, but you have to meet that standard if you're under 65 and you need long-term care. You have to be a US citizen or qualified alien, meaning you have a green card. You have to be a resident of California. Income varies, that's from state to state. California is pretty generous. The assets vary state to state, and that's because of the Medi-Cal planning, how we are able to move assets around so that we can qualify you. So it varies by state to state, but California, we're the only state that does a lot of staggered gifting, doesn't, value the entire house, things like that. California really looks out for their seniors. And I have colleagues in other states who envy us because we have such generous laws that help us qualify for Medi-Cal. Do you have any questions on this slide? Okay, so one very, very important thing, if you're applying for Medi-Cal, always tell them, even though it's impossible, there's no way, you have to say you're going to return home. I know it doesn't make sense, but if you say you're going to go home and you qualify in every other which way, they're going to disqualify you. So always, those are key words. I'm going to return home. Always put that when you talk to Medi-Cal or you put it on your application. If not, they will just immediately disqualify you. I don't understand the logic, I guess because they have to justify giving you the money. I don't know. I don't understand the logic behind it, but I know that's what you have to do. Any questions on this slide? Okay. So this is like when you hire an attorney or somebody, actually hire an attorney to do the Medi-Cal strategies. There's certain things I talked about, gifting assets, which is staggered gifting. You can gift a certain amount each day to your children, or you can transfer everything over to your spouse. Be careful about spending down just transferring an asset, because then you're going to really disqualify yourself for a year or more, or 2 or 3 years more. There's things you can do without having to actually just transfer something over. Just be really careful about that. Spousal impoverishment laws, obviously, you're both spouses and you have an estate of $1 million or whatever. We have to, the spouse is not well, we have to quote impoverished. That means we have to get their assets in their name down to under 2,000 or less, and that's doable. The spouse that's well can keep up to 130,380. This number changes every year of assets that they count. That's non-exempt. And that's a community spouse resource allowance. But okay, that's countable assets. But let's say there's other assets. They don't that are exempt, that are like high value. They don't look at that. Go figure. That's just how they do it. But if it's an asset that is non-exempt, that they would count, you can keep up to 130. But anything else that is exempt, you can have. The number is not. There's no set number. And these are just a few little strategies. Family allocation. You can be offset for the income of an institutionalized spouse for the support of a dependent family member. If you have a child at home that has special needs, or your spouse is blind or something, then there's things that you can do. So these are just some strategies that the lawyers use. Is there any questions on this? So again, as I said, plan for a recovery. They will come knocking on your door. If you're married, after the surviving spouse passes, Medi-Cal will be coming to you. Now, if the law has recently changed, hopefully it'll stay that way. If you have all your assets titled to your living trust, and Narisha will talk more about the trust and estate planning tomorrow, then they cannot collect, Medi-Cal cannot collect from you. But if you have any assets that's in your name that's not in the trust, that's probatable. When I say probatable, that means anything but a retirement plan or life insurance. Everything else is probatable, then they will come after you. If you do have to pay them back, ask them for a copy of your bill. You want to review it, because a lot of times they send you the wrong bill, or else they didn't add things up correctly. They overcharge you. You want to make sure that they have the right amount. So always ask to see your bill if you are in a position where you do have to do recovery. But as of today, if you have it in a living trust, you don't have to worry about recovery. A few years ago, I would have to do the specialized trust called the Medi-Cal Protection Trust. And it was where it was irrevocable. You would give up control of the asset. So we would give up control of certain assets, because I'm not going to have my clients without money. I won't do it, but we took away some of the assets that were countable so that they could qualify. But we don't have to do that anymore. Now we have the living trust. They just changed it. They're talking about changing it back. Hopefully they're too busy with other things and they forget about that. Any questions on Medi-Cal? Because I'm going to go into conservatorships next. Yes, sir.
If it turns out that you find out that you have assets that are in the name of a person, and it should, you should have put it into the trust, do you have time to get that taken care of, or what do you need to do?
Well, do you have control of the asset? You have title of the asset?
Well, I know I've heard comments like, you should, if you have a, say like a stock market portfolio, you should not have it as joint custody. You should have it in the name of the trust.
Yeah,
And
and you can transfer your assets into a trust anytime. There's no set time.
okay, so when if you notice that, I guess that the answer is, if you notice that you've got this sort of a situation, then you can easily transfer that's say like joint into the name of the trust, and then you're better prepared for this Medi-Cal recovery.
Exactly, because when in the trust, even though you can't hold things jointly, or it's the name of the trust, it's understood that it's 50-50, that your spouse owns 50 and you own 50.
Right.
That's a given, unless you change something in the trust or do some kind of transmutation agreement or something. So that's the best way. So highly encourage you to follow up with your attorneys and make sure your assets are correctly titled to the trust, if this is going to be of concern to you. And also, you want to do it anyway, because you don't want to go through probate. It's a very unpleasant process. It's public, it's time consuming, it's expensive, versus a trust. You might pay more money for a trust up front, but you have privacy. Things can be transferred more easily. And Narisha will get into much more detail on that tomorrow. Okay, so now I'm going to get into conservatorships. And this is what happens when you don't do any planning, any estate planning. And do most people know what a conservatorship is? Have you heard of conservatorships? Okay, so this is a legal proceeding where you petition the court to be responsible for the health decisions, personal decisions, and the financial assets of somebody who apparently cannot take care of themselves. Either they lack mental capacity, they have Alzheimer's, they're physically incapacitated, somebody's abusing them, elder abuse, what have you, and they don't know how to resist the elder abuse. And the person who would apply usually is a family member. Sometimes it's the county because there's no family members around, so the county will apply for it. And you apply to be the conservator. You would be taking over that person's assets and taking over the care of that person. The conservatee is the person that needs the help, the person that you're petitioning to help. And there's different types. You can you can petition for a person, just take care of their health things. For the estate, if you do that, you need a bond. And then if you can do for both. The county or the courts are very, very reluctant to grant these. You have to really show that the person cannot take care of themselves, because in effect, they're taking away your civil rights to make your own decisions. So you need doctor reports. You need specific examples, like they left a stove on and the house almost caught on fire. You need a lot of information to pass the standard to get the court to grant one. They are not easy to get. I have a case where, well, this was procedural. It wasn't where it was very obvious. And I had a doctor's report and they would not give me the conservatorship, but this is more procedural than the thing, because we couldn't serve her notice. So even though she was like losing all her money and everything, they wouldn't grant it. They take it very seriously before they take away your rights. Any questions on that? So that's why I hope all of you have some kind of trust, power of attorney, healthcare directive, because if you have that, generally you shouldn't be worrying about a conservatorship, because you would name somebody to take care of you. But there are situations where the proposed conservator, they haven't been, only a court can declare you mentally incapacitated. The doctor can write a note, and that's a medical opinion, but legally, in order to take control of you or your assets, the court has to state or has to say that you are incapacitated. So sometimes, people have these documents, these estate planning documents, but they have the power to withdraw them. So if you're worried about someone, who's really not well, and they're going to withdraw it and, have like somebody who's not caring for them, someone who's, using them, then you would go for a conservatorship, even though you have these documents. But if you don't have that issue where you're worried about someone taking advantage of somebody and making them, revoke their estate planning documents, you should be okay. And as I was mentioning before, and if you do have an estate plan, you have to worry about fraud or undue influence. And there's unfortunately a lot of examples of that, people taking advantage of the elderly. They're like locusts. They seem to know when someone is not well, and they seem to come around and take advantage. So you have to show that. And well, Marisha would talk about doing the estate plan. It's important so you can avoid a conservatorship and or a probate after you die. Because if you don't have an estate plan, you got to go through probate, and it's not a pleasant process. And I'm assuming Narisha will address that tomorrow. Limited. So this is.
Ivette,
Yes,
sorry,
ma'am.
I just want to interrupt 1 minute. In case you're wondering who Narisha is an attorney and on our Legacy Advisory Council, and she'll be giving a 10 a.m. session virtually on estate planning. So I'll be sure to send a link and also email all of you that information after this.
Yeah, she's a great attorney. I know her personally, and she's an amazing presenter, and she'll give you all the information you need about estate planning. So limited conservatorship, that's used primarily for somebody who's developmentally disabled, where a general conservatorship is not warranted. The courts want to encourage somebody, disabled young person, or even somebody who is elderly, to be able to, if you can do certain things for yourself, they want you to develop those skills, and the things that you cannot do for yourself, then they will appoint somebody to help you with that. So when you do a limited conservatorship, you have to put down the specific powers that you want, and those are the only powers you get. I had a case yesterday where I had a young man who really couldn't do anything. And the court investigator, they investigate and they make a recommendation to the court. She was saying, well, why isn't this a special? And I said, he can't do anything for himself. And it just shows you how much they're worried about maintaining your rights, because a general means they can do almost everything except have you sterilize, experimental treatment, stuff like that. But general gives you a lot of authority. But sometimes you have a youth person who needs a general, and the courts are very reluctant to grant it. You have to really make a case. They rather use a limited because they want to give you some freedom. So that's it for primarily for someone who's developmentally disabled. Any questions on this one? Okay. The general, as I said, encompasses everything. You can do almost everything for that person. This is the law, Due Process and Competence Determinations Act gives you the standards for determining someone's legal capacity. You have to overcome the presumption that the person can't handle their affairs. Clear and convincing evidence is the standard. It's a very hard standard to follow, but in a way, I'm kind of glad they make it difficult, because I wouldn't want someone to take away my powers to make my decision if I want to go to the movies or if I want to go for a walk. I don't want to have that limited. I really want them to prove that I cannot do that. I cannot take care of myself. So in a way, it is a good thing. Fraud or undue influence, which we spoke about, which unfortunately the elderly is susceptible to people who are just taking advantage. Again, we have to present evidence of that happening. Like sometimes you have a child, which I cannot comprehend, clearing out their parents' bank account. I don't understand that, or using the parents' credit card. It just doesn't make sense to me, but that's an example of what we would use. Any questions on a general conservatorship? Okay, so now within the limited and the general, sometimes we have an emergency. Like we really need to get this person conserved, because if we don't get them conserved right away, they're gonna have, they're gonna be harmed, terribly harmed, and it's gonna be irreparable. But that's a very high standard. So we would do what's called a temporary conservatorship. So it talks about physical abuse, neglect, abandonment, isolation, abduction, deprivation of, feeding them, letting them care for themselves, stuff like that. You have to prove that to the court. And usually we do what's called ex parte. We go in and we make a special motion and rush in there. And if you have a good showing, the judges will grant it. But you don't waste their time if you don't have a good showing. So that's really to protect someone who's being taken advantage of and they needs help right away. Any questions on the temporary? Okay. And I don't know if there's chat. I don't see anything in chat box. Okay. All right. Now my last topic is special needs planning. So hopefully you got a flavor for each of these areas, and I'm always happy to answer questions. So the special needs is for someone who's developmentally disabled. Social Security is the one that sets up the rules and regulations for that. They're called POMs, and they change them every day. So you have to really be on top of it. But the reason you would do special needs planning, and one of the main tools is what's called a special needs trust, is to preserve the public benefits, to provide lifetime financial support. So for example, I have a lot of young people, their parents are worried about what's going to happen when they're gone. And again, if you want to qualify for government benefits, there's a lot of programs that people who are developmentally disabled, they qualify for, but they cannot have more than $2,000, the same as, Medi-Cal. So what we can do is set up a third-party special needs trust, and that money would be used to pay any services they need. It can't replicate what the government provides for you, but it can pay for other things like going to a show or going out or what have you, or getting a new car or something, so you can have a better standard of living. So that's what one of the main reasons you would do special needs planning. And also to provide supplemental lifetime financial support by buying additional services, which I just spoke about. Also providing a system of advocacy to preserve civil rights. That's so important. And in the law of the trust, they talk about that. Either you have a committee that will meet yearly to evaluate how the money is being spent, how the special individual person is being treated, what needs to be done, or you have professional person, you might have a fiduciary who is specialist in special needs planning. I don't know, you can use an attorney if you want, but just someone to make sure that this person is being taken care of, because obviously a parent, no one can love their child like a parent. So this is the second best thing you can do if you're not there, is to set up a special needs trust. So at least you have some guarantee that your child will be cared for. And if they're not, there's remedies to address it. And I talked about the management team, provide a safe and clean living arrangement. You can, like with a third party special needs trust, you can put aside money to buy a house or have someone come in the house and help that person. You can do pretty much anything. A lot of times people are able to work. So there's things that can be done so they don't disqualify. There's ABLE accounts that just came out recently, and you're able to, it's like a savings account for the disabled that won't disqualify them from the government benefits. So they can have more than $2,000 a month. It's an exception because it's a savings account. And just to make life, pleasant and as normal as possible for people with special needs. That's what the Special Needs Trust community is involved in, and that's what the trust hopes to accomplish. Any questions on this?
I do. Okay, so
Yes.
I have a friend that I've known since kindergarten, and his mom left a trust in his name, and she passed away. The conservator or somebody, trustee, stepped in that she had set up, and she had a couple houses and some money in the bank, and the trustee just blew through it in 5 years, went through $300,000, the savings from a house in SoCal that he had inherited.
That's terrible.
I know. And so the guy called me up and he said, the guy who needed the help, could you please help me? And I said, yeah, I'll step in and do what I can. And I went to an attorney down in Santa Clara and I said, I need to help this guy. Tell me what I need to do. And so she said, set up a special needs trust to protect him.
Yeah.
But the only money he has is the house that he's living in, and he doesn't want to sell it.
Right.
So she set up, went to court, got it all set up for us. But what's the money he's supposed to live on? He gets Social Security like $600 a month, and it's not enough for him.
Yeah. Is the house paid off?
Yes.
Yeah, maybe. So it sounds like it's a first party special need. How old is the
65, but he's
65? Yeah.
mentally disabled.
Yeah.
But
that's
but
a
here
shame.
I'm stuck. I was the one who got him into this. Now we're in a special needs trust. And the problem is you can't borrow money against a house in a special needs trust.
Well, you can ask the lawyer to file a petition to get the court's permission to do that. And maybe they'll make an exception. That's so sad that the mother left everything to him in a regular maybe you can take some action against that trustee, whoever it was, because apparently they didn't do the right thing by this person. So maybe there's some cause of action against him. It's some kind of abuse.
Yeah, him and a lot of other people, I'm afraid. But
yeah, I mean, that's just terrible. I mean, there's
something I could do to get that, go back to court and say, I want to, or go to see you to say, take me back to court to be able to get that.
How long ago did this happen?
Oh, within the last 5 years.
Okay, I don't know. I'm not a litigator. I don't know if I could recommend you to somebody. I don't know if because the statute of limitations might have passed, but.
Oh yeah, no, I'm not talking about that. If I wanted to either A, get the house out of the special needs trust, or B, be able to get a loan against the house that's in the special needs trust.
Yeah, exactly.
I've talked to lenders and they say they won't even touch a house in a special needs trust because he doesn't have control of it.
Yeah,
so,
yeah.
But boy, if I can save one other person from making that mistake, never put a house in a special needs trust.
That's
an asset.
There's an attorney who's like the guru of special needs. His name is Kevin Erspach, URS. Let me put this. And he's very generous with his time. He's like, and that's such a special, maybe he can think of something because.
Okay.
I don't have his phone number, but look him up. And
I will. Thanks.
He's a very kind person. I mean, he's busy. He's always giving lectures, but this is a very unique situation. Maybe he can think of something that I can't think of.
Okay.
Because obviously the banks don't want to help him. I don't know how to get around that. I can go to court and ask, but if they're not going to loan it to you.
No, and I could sell the house from under him, but this is
where's he going to live?
His father built, so it means so much to him sentimentally. So I know as a trustee, I'm not supposed to do this, but I've been loaning the money to live on.
Oh, that's very nice of you.
Yeah, but
you just keep an accounting of all that. So.
Yeah, I know, but I'm not supposed to do that. A trustee doing personal stuff. So
you got to be careful. Yeah.
I know.
Well, that's very generous of you. I
I'll
feel-
just I have a thought that maybe the lawyer can help you with. There might be a way of getting the house set up so that you could do a reverse mortgage on.
That's what I was wondering.
Yeah, but it only gets him about $350 a month because he's so young. And that's not enough to make up for what he needs to live on.
Well,
So
then-
I'm giving him about $600 a month on top of his $600.
Is
Plus
he
I
getting
pay all
Social
of-
Security? Is he getting, there's other benefits he might qualify for.
They usually have SSI.
Yeah,
Yeah,
he might
Yeah.
qualify for other benefits. You just have to find out what they are.
yeah.
Maybe this lawyer can come up with some good ideas.
Yeah, okay, thank you.
No, I had troubles with my mother, and the lawyer really helped me a great deal. So I think you need to find a really good lawyer to help you.
Yeah.
Okay, thank you.
Yeah, I'm sorry. So then I talked about the third party set up by someone other than the person who needs it, and they put their money in. You still have to report to SSI, Social Security. They want to know what you're doing. And this allows the person to have a good standard of living and still qualify for government benefits. Then you have the first party special needs trust, like your friend, you went to court. So the court set up the trust for him. If he was under 65, he could have done a trust himself. They have a new law that just came out a few years ago that allow you, if you have the capacity, obviously, to set up your own special needs trust. The only caveat with the first party is that the beneficiary, if there's any money left, it has to go back to Medi-Cal to repay them. With the third party, it could go to another person. So let's go back to the Medi-Cal example. You have the trust and one spouse is in a nursing home, the other one isn't. And the spouse that's not in a nursing home dies and leaves everything to the spouse that's in the nursing home, and they're using Medi-Cal. They're going to get disqualified. So what you would do, you would set up in the will language that instructs the executor or successor trustee to set up a special needs trust. So this way they can still take advantage of the money and not lose their benefits. So that's something you would do, if you had resources and you want to leave it to your spouse, you don't want to just not leave it to them. You want to make sure they can at least have the benefit of that money. So I think I used up all my slides. Libby, I think I'm done. So now let me give you control again.
Can I ask you a question?
Of course.
You just said executor or successor trustee. What's the difference?
A successor trustee is a fiduciary for a trust. And I don't know why they use different names because they're all fiduciary. They all have legal responsibility. An executor is the fiduciary for a will. And for a power of attorney, healthcare, it's an agent. But it means the same thing. They just gave it different names just to make life more interesting for you.
Okay, thanks.
Let me put you back in charge. You're back in.
Hey, we have about 15 minutes to our hour. This is a time just for discussion. Any questions while we have Ivette, if you have any more?
Yes.
Yeah, I have a whole bunch of questions. I don't understand totally all these options on the different kinds of charitable trusts and how you can set them up in different ways.
Okay.
Is that something that the lawyer is going to talk about tomorrow morning?
I probably not. That is very advanced and that would take up the whole hour or more. So you can ask her, but I don't think she's going to really discuss it. I mean, are you working with an attorney? Do you have somebody now?
I came up with all these questions after reading this little, the Legacy newsletter about the two talks.
Oh, okay.
And they had some illustrations, in there on various examples of how people did this. And I have a whole bunch of questions based on those examples. And so I was wondering who could address those, or
I could, but there's no time. But Libby, is there someone who can help him?
No, I think it's great. And those are going to be really good questions, I assume. So what I would suggest is emailing me. And what I can do is send the questions out to the Legacy Advisory Council group that we have to see if anyone's interested in meeting with you, because we do have a handful of members that provide, 30-minute, 1-hour free consultations. But we also have a couple board members who are really, really knowledgeable in charitable giving. So I'm going to shoot my email through the chat box.
Oh yeah, I don't see it there. I see a website that you have there. There we go.
There it is.
See it?
Yeah, I'm just going to copy it here. So
Okay, and I'll be sure to email everyone afterwards too, because I would like to email you information on tomorrow's Zoom with Narisha on estate planning. It's called What's on Your Mind, a chat with Narisha. But it will be all about, she'll present for maybe about 10 minutes on estate planning, and then it will be mostly a time just for question and answer and talking.
so she won't be able to answer any of these questions about these different kinds of charitable trusts either then.
Yeah, well, it depends on what you're trying to accomplish, and there's different types of charitable trusts. So that's why you would have to need a one-on-one, especially with someone who knows how to do them, an attorney or someone on the
Right.
board. And then they can tell you the right one for you, because there are various ones, and it's
Right.
it's very in-depth estate planning. You have to really
Right.
know, because there's a lot of tax issues involved.
Right. Yeah. And that's what's of interest to me as well. So I'll try to summarize these things and send an email to Libby, and maybe she can put me in contact with somebody.
Please do. That would be great.
Okay. Thank you.
So what is the program that's tomorrow?
I will send it to the chat, but I will also email everyone a direct link. So
Okay.
what we've done this past year is we've hosted about 6 virtual presentations that are hosted by members like Ivette that present education information on certain topics within legacy or estate planning, how to find your value through your philanthropic giving. This coming year, we'll be hosting a lot more of those, as well as hopefully in-person seminars too. We'll just have to see where the world lands. So Narisha is going to actually wrap us up for the whole year. And she is an estate planning attorney that's just going to be having a more casual conversation over Zoom from 10 to 11 tomorrow. So I will send you the link to register for that, same as this, and you'll receive an automated confirmation with the login information.
Okay, thank you.
Yep. Are there any other questions? I
Well,
don't.
All I can say is that lawyers are a wonderful thing.
Oh, thank you.
The world is so
That's
complicated.
nice to hear.
How would we get by without lawyers, you know?
I
Well,
know.
especially when they're good lawyers. There's a lot of good
Right.
lawyers out there.
Right. Yeah, good lawyers are worth.
Just a few
worth
bad
it.
ones that give us a bad reputation.
I know. That's the jokes are always about all the bad lawyers, but
Yeah.
there are a lot of good lawyers.
Yeah.
Especially Ivette, especially when they
Oh,
give their
thank
time
you.
back, which Ivette does to cancer support community. She's going to be doing that a lot more next year. So thank you so much, Ivette, for
Oh, my
she's
pleasure.
had a crazy busy
Very
month and she wanted to take time out to do this. So we
I
really
couldn't say
appreciate
no.
you.
You got me.
No, she couldn't say no. So thank you. And thank you
Okay.
all
Thank
for
you.
joining.
Nice
and
meeting all of you. And if you have
Yes.
any questions, feel free to email me. or whatever.
Thank you so
Okay.
much.
All right.
Thank you. Thank
Yes.
All
you.
right. Thank you, Libby. This was fun. Thank you so much.
Enjoy your night.
Okay. Bye-bye.
Thank you.
You too.